Hello friends! Do you find yourself in the middle of a divorce proceeding and late at night thinking to yourself, should I try to settle at mediation or should I roll the dice and try to go to trial? Well, today we got you covered. We're going to talk to you about the benefits of mediation versus having to go to trial. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. All right, so let's first talk about what mediation is. It is a court-ordered meeting where you have to try to go with you and your attorney to meet with your soon-to-be ex-spouse and their attorney, if they have one, as well as the mediator, and sit down and try to either put together an agreement regarding the stuff. It's usually called some sort of marital settlement agreement or some sort of distribution of property agreement, depending upon the jurisdiction. And with all of the issues regarding the children, you will execute or try to fill out what's called a parenting plan. So mediation requires you to either go in person or on Zoom, meet with your attorney, meet with the mediator, and try to work out your case and see if you can draft these documents together. This is much different than a trial. A trial is exactly what you see on TV. You will have to show up to court. You will have to be there with your attorney if you have one. Your spouse will be there with their attorney if they have one. The judge will be there. There may be a court reporter, an interpreter. As soon as you walk into the courtroom, it's full go. Everyone's gonna play their part, play their role. Your attorney's gonna make their opening statements. Then they're gonna call witnesses. You may have to testify. Then your spouse's attorney's gonna do the same thing. They're gonna call witnesses. They'll have to testify. And then after however many days of trial, depending upon how complicated your case is, the judge is gonna decide your case. And that's it. So we'll talk about some of the benefits of settling at mediation as opposed to rolling the die and going to trial right now. All right. First and maybe foremost is that mediation is a lot more cost effective than going to trial. Leading up to mediation, you usually have to complete some sort of financial discovery, whether it's hand over your financial documents like your pay stubs, your bank statements, your tax returns, and things of that nature. If there's a home or if there's real property, you might have to conduct an appraisal beforehand. And if there's a business or some sort of other asset of value, there has to be some sort of valuation, either by a forensic accountant or a regular accountant or whoever you agree to. In addition to this, there may be some preparation time with your attorney, because hopefully you're not walking into a mediation without having spoken to your attorney, although it happens, and that's pretty terrifying when I hear that it does. But anyway, you'll go to mediation, you'll pay for your attorney's time. There's some preparation involved in that. You'll have to pay for the mediator, but usually, although that I'm not saying that is cheap, it is way cheaper or less expensive than if you have to go to trial. If you have to prepare for a trial of your case, remember that the discovery becomes compounded, becomes bigger. So you're going to have to conduct depositions of witnesses, and that takes time and money, especially for the transcripts. In addition to that, you're going to have to prepare trial exhibits. So think about whatever your life is that you're trying to show the judge, whether it be bank statements or photographs of your kids or proof that somebody was cheating or the bank records that show that there was waste or dissipation of assets. All of those things have to be cataloged and marked as exhibits, and it is extremely time consuming and extremely costly. In addition to that, your expert witnesses, whether it be a forensic accountant, whether it be a business valuator, whether it be a vocational expert, all of those people are going to have to testify. And from the moment they leave the door to the moment that they're done testifying, the clock is going to be running and they're going to be charging you. In addition to this, witnesses are going to have to appear. So if you have friends or family that are witnesses, they're going to be pissed at you because they got to go to court and miss work. If it is some of your children's teachers or their karate instructor or their football coach, get ready. They're going to be upset at you too. So that becomes a problem when having to call witnesses. So all of these things are something that you should keep in mind if you decide that you want to go to trial. Up next, trying to settle your your case at mediation versus trial has another significant benefit, and that is that mediation or settling at mediation tends to be much quicker than having the case go to trial. First of all, a lot of judges, or at least here in Miami-Dade County, they require you to go to mediation first. So you're going to have to do it anyway. In addition to this, you have more control of the speed of the negotiation, whether it lasts 2 hours, 4 hours, 8 hours. I had a mediation last 2 days on the day that the clock fell back. So I was there 2 days plus an extra hour. But you are focusing all that time with your litigation team to try to settle your case. Whereas a trial, number one, you have no idea when the case is going to get set. They are setting cases now, at least in Miami-Dade County, maybe like 4 months, 5 months down the road, just for a final hearing. That's like half a day. If your case is more complicated, you may not get a trial date for 6 months to a year down the road, depending upon the docket size or how many cases are in the system, and depending upon the availability of the judge. In addition to that, you don't know how long the trial will be. If you're set for a 3-day trial and something happens, let's say somebody gets sick, the judge gets sick, or there's a judicial conference, or let's say because attorneys are notorious for asking for too little time, the trial doesn't finish in 2 or 3 days, you will get continued further down the road whenever the court has an opening. It could be another 4 or 5 months down the road, and you don't get to pick that time. Also, when the case is over, let's say that you present the evidence at a final hearing, the judge doesn't always rule off the bench. A lot of times the judges will ask for either closing argument that is written, or if they allow for oral closing arguments, maybe they want some additional memos, or maybe they will ask the attorneys to submit proposed orders. Getting that proposed order executed and signed by a judge could be a couple months down the road because they have other cases. They have thousands of cases on their docket. So you may not even get the ruling right after the trial in the case. So that is another delay. So if you look at how trials work, it is clear that mediation offers a quicker result. The next benefit of mediation versus attending a final hearing or rolling the dice at a final hearing is that it reduces the conflict. It reduces the temperature level between the parties. Mediation, remember, is a voluntary and collaborative process. It encourages open communication between the parties and their counsel, which helps preserve relationships, especially if you have children together. This is much different than if you prepare and go to a trial or a final hearing. Number one, you're going to have to depose your spouse, and that is very uncomfortable. In addition to that, you are going to be in trial having to, number one, answer questions from your spouse's attorney, and it can get uncomfortable. No matter how great a speaker you are or how comfortable you are addressing or dealing with conflict, attorneys are trained to go after you and make you feel uncomfortable and make you second guess yourself and make you feel upset and maybe react. So going to a mediation instead is something where you don't have that adversarial process and is a big plus. Up next is privacy. Mediation is a private process, which is wonderful. If you prefer privacy, mediation should be your choice because people don't have to know about your settlement. As a matter of fact, as a condition of mediation or whatever agreement you come up with at mediation, you can agree with your spouse that it will be confidential and no one gets to look at it. However, if you go to court and if you go to trial, let's say you roll the dice on trial, number one, it is a public courtroom, so anybody can walk in the door. When we've had celebrity clients that we represented, it is unfortunate, but the media shows up, other people show up, and they are frontline news. In addition to that, anything that is submitted in the court is a public record. That means that anything that's in there, people from the outside can come in, go to the clerk's office, and get a copy of it. So if you prefer privacy, mediation is the way to go. One of the big selling points, at least that I make to a lot of our clients, is that mediation allows for customized solutions. It means that you can become creative with your spouse to agree to things that are best for your family, even if that is not allowed for by law. Some of the prime examples are cell phones for the kids. The Florida statute doesn't require anybody to pay cell phones, but we know that our children need cell cell phones nowadays. Automobiles or the cars. When our children turn 16, Florida statute doesn't mandate that you have to pay for your children's car or their car insurance. Also, college, room and board. I'm a big proponent that, unfortunately, child support in Florida cuts off at the age of 18 for some of the kids that want to go to college. I say unfortunately because if they go to college and parents are unable to chip in for whatever reason, or if they refuse to chip in, then they're going to have to take loans and they're going to have to be very careful with that. However, if you go to mediation, you can make a provision for children to get some sort of contribution from both parents for tuition, room and board, and books and things of that nature. So I think that's a plus. If you roll the dice to trial, the judge is constrained by what Florida statute dictates. So that's not a bad thing. I think the legislature has done a pretty decent job at trying to hit all of the different points. So when it comes to equitable distribution, you're stuck within the parameters of the assets and liabilities of the parties. When it comes to alimony, you know there's no permanent alimony anymore, so you're stuck with it. If it comes with regard to the children's issues, there may not be as much flexibility now because the courts are constrained by the statute. Although equal time sharing now is a presumption, maybe the couple doesn't want to do that. So it's important to note that mediation allows for you to be creative and come up with solutions that might be better for your particular family that would not be allowed under Florida law. And finally, one of the bigger selling points is that there may be more satisfaction with the results of the case. Now, I'm not promising that if someone attends a mediation conference and come up with an agreement, they're going to be really happy about it. As a matter of fact, if the parties are both a little bit upset about the mediated agreement, then that means the mediator probably did a good job. Parties showed up and they were able to agree and compromise. So if them being not happy is usually a good sign of a good mediation. However, no matter what the result in mediation, the parties are the architects of their agreement. So they'll tend to be a little bit more accepting of the end result. Whereas if you roll the dice to a trial, you get your trial exhibits ready, your discovery done, you walk into court with your attorney, and the show goes on after closing arguments and the orders are submitted. If the judge decides against you, whether it's by a little bit or whether it's huge, somebody's probably going to be a little bit salty while the other parent is probably going to be happy. And this in turn, what may lead into discord moving forward because there is an actual winner and there is someone that is considered more of a loser in the case. So that's some other food for thought as to why mediation may be a better option. Some final thoughts on mediation. It's important to note that mediation may not be suitable for all of the divorce cases, especially when it's cases that have domestic violence involved or cases in which there's a highly contentious case. In such cases, there may not be another way to resolve the case than to go to trial. Remember, if there is domestic violence and there is a mediation conference, that there be an order that allows for the mediation to continue if the parties are attending in person. That's a very important pro tip. All right, so that is a wrap and some food for thought as to why you may consider settling at mediation instead of rolling the die and going to trial, because you never know how all that's going to end up. Nevertheless, if you know anyone that might benefit from this video, please have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida. Se habla español. Please do us a favor and like this video and subscribe to the Divorce Broadcast channel, and we'll talk to you soon. Thank you.